Properties Limited is about to evict Msambweni residents from, measures 54.26 hectares, and is registered as number 1956/506, CR number 23979. That the residents of Msambweni have lived peacefully in their land since 1938. That in 1978, Msambweni elders accepted a request by Butter Shoe Company to put up a shoe factory in the land they were living in because the investor intended to create employment for local citizens. That Butter Shoe Company proceeded to acquire a 99-year lease grant of the land given to it by the elders effective 1st January 1979 from the Ministry of Lands on the following terms and conditions, among others: A, the land and the building to be put up shall only be used for a Butter Shoe Company and accommodation for a caretaker or a night watchman. B, the grantee shall not subdivide the land. C, the grantee shall not sell, transfer, or sublet the land. Number 6, that for over 31 years, from 1979 to 2011, Butter Shoe Company did not put up any shoe company, but instead sold the land at Kenya shillings 12 million to Sparkle Properties Limited in 2013 for purportedly constructing a shopping mall in total disregard of the terms and conditions of the grant. 7, that in 2011, Sparkle Properties Limited attempted to develop the land, or attempts to develop the land were resisted by Msambweni residents because the company was a stranger to them. That in 2013, Sparkle Properties
Let's
Limited...
consult in low tones, senators.
Sparkle, even my chair, Lands Committee chair, should be listening to this one because I know it involves him directly. Number 8, that in 2013, Sparkle Properties Limited filed a suit in the Environment and Land Court of Kenya, suit number 265 of 2013, seeking to evict over 3,500 Msambweni residents living in 500 households to pave way for her to develop the plot. That the case was heard and the judgment given in 24th February 2020 in favor of Sparkle Properties against the residents of Msambweni. That among other things, the judge in his judgment ordered: A, Msambweni residents to pull down their houses and leave the land vacant. B, Msambweni residents to pay general trespass damages of 1.05 million. C, Msambweni residents to pay costs of the suit. Number 11, that if the court orders are executed, 3,500 people, Mr. Speaker, will be rendered homeless for being evicted from their ancestral land that they have lived in since 1938. That the residents of Msambweni have no other land anywhere that they can settle in case they are evicted. That efforts to resolve the matters raised in this petition with the relevant authorities have proved futile. That there is no case pending in court or any constitutional body on the matters raised in this petition. Herefore, your humble petitioners pray that the Senate, through its relevant committee, 1, deals with this petition immediately in view of the urgency and seriousness of the matter. Officers, the Sisal Estate Management, and political leaders in the county, except me, met the residents of Mkamenyi and promised to give back the land being illegally occupied by the Sisal Estate to the residents. 10, that on 29th October 2019, the management of Voi Point Limited invited 3 representatives of Mkamenyi residents to a meeting at Ngutinyi Lodge, where they informed them that A, the management would give them 35 acres of land instead of the over 150 acres they were occupying and have been claiming. B, the 35 acres were being offered or the 35 acres which were being offered would be used to settle 28 families occupying the disputed land. 11, that the 3 members refused to accept, that the 33 members refused to accept the offer of 35 acres, claiming that it was not adequate and that they needed more than 150 acres that the residents of Mkamenyi were initially occupying. That the management of Voi Point Limited proceeded to do survey and beaconing of the 35 acres of land they promised to offer without involving the residents or the county government, and processed a group title deed for the same. 12, that on 25th August 2020, the management of Voi Point Limited invited the residents for the issuance of the 35-acre title deed, but the residents rejected it due to the following reasons. A, the residents needed more than 150 acres and not 35 acres that they were being offered. B, the group persons who did not live in Mkamenyi listed as owners of the land. C, the names listed in the title deed as owners of the land were only 6 families, leaving out 22 families. 13, that residents to efforts to resolve the matters raised in this petition with the relevant authorities have futile. 14, that there is no case pending in court or any constitutional body on the matters raised in this petition. Herefore, your humble petitioners pray that the Senate of Kenya, through its relevant committee, 1, deals with this petition immediately in view of the urgency and seriousness of the matters raised herein. 2, investigates the circumstances that led to A, the decision to offer 35 acres of land and not the more than 150 acres of land, which is adequate to settle the Mkamenyi residents. B, the carrying out of survey and beaconing of the land without involving the county government or the residents. C, the listing of names of persons not living in Mkamenyi as owners of the land being offered title deed. 3, makes a declaration that the process followed in the offer of the 35-acre of land and its title deed to the residents of Mkamenyi was unprocedural and unlawful and therefore null and void. 4, recommends that the Ministry of Lands initiates an all-inclusive, open, and transparent process of giving the residents of Mkamenyi adequate land that can settle them once and for all. 5, takes any other appropriate action it deems fit to resolve the matters raised herein, and your petitioners will ever pray. I thank you, Mr. Speaker.
Okay, honorable senators, pursuant to standing order number 231, I shall now allow comments, observation, or clarifications in relation to the petitions for not more than 30 minutes. Senator Agnes Zani. Senator Madzayo.
Asante Bwana Spika. Bwana Spika, nataka kuunga hii hoja ya statement ya huyu ndugu yangu Maruma, seneta wa Taita Taveta, kuhusikana na hili shamba la Msambweni ambalo liko katika Voi constituency na ambalo ni eneo la Taita Taveta county. Bwana Speaker, tunaona kwamba hata swala hili ni kama vile ambavyo liko katika hii Kamenyi, ile kikao kile ama village ya Kamenyi ambayo iko hapo katika maeneo hayo ya Taita Taveta. Bwana Speaker, tunaona kwamba shamba hili ukiangalia historia yake kwanza ni historia ya kusikitisha. Shamba hili japokuwa kulikuwa na wenyeji pale wanaishi, lakini wale wenyeji walichukuliwa kama ambao ni wanyama, na shamba hili likachukuliwa likapeanwa kwa mzungu kwa sababu zisizoeleweka, lakini ilipeanwa kama zawadi, hali ikiwa ndani ya hilo shamba wenyeji wanaishi hapo, sio wanyama. Bwana Spika, ni jambo la kusikitisha kuona vile vile ya kwamba shamba hili katika mkoa huu wa Pwani si mara ya kwanza, si mara ya pili, na haitakuwa ya mwisho kusema kwamba mashamba mengi sana ambayo katika maeneo ya Pwani yamepewa kwa watu binafsi kama zawadi ama kama gift vile ya kumfurahisha mtu. Hata tukikumbuka sisi tukipata uhuru, Rais wa Jamhuri ya Kenya mwenyewe wa kwanza Kenyatta aliweza kupeana sehemu fulani fulani kama zawadi kwa watu fulani fulani ambao hivi sasa ndio wana mabonyenyi wakubwa katika maardhi yaliyoko huku baharini na maeneo mbalimbali ya pwani. Bwana Spika, tunaona ya kwamba katika maeneo haya ambayo hivi sasa...
Senator Anderito, what's your intervention?
Bwana Spika, singependa kwa sababu vile ambavyo nimesikia seneta mwenzangu akisema kwamba rais wa kwanza alipatia watu fulani mashamba kama zawadi, lakini sidhani kuna jambo kama lile ati watu walipewa kama zawadi. Watu wengi waliotembelea sehemu zile ama katika mashamba yale walinunua kwa hela zao, Bwana Spika, na nina ushahidi. Kwa hivyo na sijui ni nani fulani. Watu wana majina yao. Hakuna watu fulani. Kama ni kikundi cha watu kinajulikana, hamna haja ya mtu kusema watu fulani ilhali anajua pengine majina yao. Na wale walioko huko kama ni zawadi, hakuna zawadi, Bwana Spika. Wengi walioko katika sehemu nyingi za Kenya ni watu walionunua mashamba kwa pesa zao. Asante.
Senator Sakaja, there's another intervention.
Mr. Speaker, it's actually similar. Mr. Speaker, it's very easy to casually make a claim like that, maybe out of conventional talks out there. But the standing orders demand that every member should be responsible for a statement of fact. Mr. Speaker, I would just like to ask Senator Madzayo, or rather to ask whether it's in order for him to say that the former president gave land as gifts to people in that county. And if so, Mr. Speaker, he should substantiate or withdraw, Mr. Speaker, because you can't just fly around with that. We would like to know who are these who received gifts. And even once we know, we'll ask where our fathers were. They should have also received gifts during that time, Mr. Speaker. So may he substantiate or withdraw that statement, Mr. Speaker.
Senator Mataya.
Bwana Spika, sijui kama ni kwa sababu ya sintofahamu za hawa ndugu zangu Seneta Sakaja ambaye namheshimu sana na Seneta Kinywa kutamka maneno kama hayo. Statement hii ambayo imesemwa hapa na ndugu yangu Mwaruma kutoka Taita Taveta inahusikana na mkoa wa Pwani, na sehemu hii ambayo imetajwa ni Msambweni na Kamei ambayo iko ndani ya kaunti ya Taita Taveta, na aliyepewa ni askari jeshi wa kizungu ambaye ametajwa hapa na ndugu yangu Maruma. Vile vile tunasema ya kwamba kuna ile TJRC report ambayo iliweza kusema wazi kabisa ni kina nani na kina nani ambao wamepewa ardhi ya Pwani. Na la mwisho, kama ndugu yangu Kinyua hajui, basi chanzo cha Lake Kenyatta anakijua yeye. Tuliuliza matingatinga tukapewa watu. Kama hiyo si zawadi, sijui kama kuna zawadi nyingine tena. Bwana Spika, ni jambo la kusikitisha mpaka hivi sasa ambao tunaongea swala la Taita Taveta, si shamba peke yake, bali hata milima iliyoko ndani ya Taita Taveta, kuanzia Voi mpaka milimani huko ambako watu wanatoa tanzanite, wanatoa ruby, wanatoa ile green granite, ambao ni rasilimali kama dhahabu, ina pesa nyingi zaidi, haiko katika mikono ya Wataita. Bwana Spika,
he referred to the report, the THRC report.
Bwana Spika,
Okay.
Bwana Spika, tunajua ya kwamba ni nia ya serikali kuona ya kwamba kila Mkenya amepewa nafasi ya pale anapoishi aweze kupewa. Na hawa watu wa Msambweni hawa ambao wameleta hii petition katika ndani ya Senate, wasichukuliwe kama ambao si wa Kenya wengine. Hawa ni wa Kenya na wana haki ya kuleta swala lolote ndani ya hili bunge la Senate. Kwa hiyo Bwana Spika, mimi nasema ya kwamba na ni matusi mpaka kufikia saa hii kuona ya kwamba wao walikuwa wanaketi ndani ya ardhi ya eka 150 kuambiwa wachukue eka 35. Bwana Spika, kama kuna matusi ya mtu akikutukana ni ya kuambia wewe ulikuwa na ardhi ya eka 150, hivi leo naambiwa chukua eka 35 uende zako, chukua ama kataa ama kwenda zako. Hii tunasema kudharauliwa namna hii. Sasa sisi tumesema ukome ama ufike mwisho. Bwana Spika, hili swala la ardhi ni swala la uchungu sana, la si swala la kuchukuliwa mzaha vile wanasema. Sijui kama ndugu yangu Sakaja anasema mwambie aseme ni nani na nani alifurushwa, akijua kila siku kunatoka order. Na mimi kila siku ninaenda police station kutoa watu wangu wa Giriama wameshikwa, wanawekwa ndani, watu wanashikwa, wanafungiwa katika police cell, wengine wanatupwa katika ile mayadi ya askari, wanaambiwa wameingia. Askari wenyewe sasa wa kutoa Kilifi, hakuna kazi wanaofanya isipokuwa kungoja service ya injunction waende wakafukuze watu katika mashamba yao. Wakiambiwa kuna wezi mahali fulani, wanasema hakuna gari haina mafuta ya kwenda huko. Lakini wakiambiwa sasa hapa ni kwenda kutoa wale wagiriama pale ndani na kuweka watu wengine, hiyo nafasi ya kwenda huko na petroli inapatikana. Sisi tunasema Bwana Spika, Bwana Spika, mimi naunga mkono sana ndugu yangu Maruma vile amesema. Asante Bwana Spika. Na hiyo kamati ambayo Bwana Spika itakuwa imepewa jukumu hili, ile kamati ambayo inaongozwa na Githiomi, ni kamati ambayo ni lazima ishurutishe ya kwamba hawa watu ambao wanaishi katika hii eneo la ardhi wapewe ardhi zao zote 150. Asante Bwana Spika.
Senator Yes, Chariot. Yes, actually, Senator Chariot.
Thank you, Mr. Speaker. Mr. Speaker.
Shamaliza, Senator, proceed.
Asante, Bwana Speaker. Mr. Speaker, there's an increasing number of petitions coming to this House lately. And this is testament of the belief that Kenyans get that when they present their issues before this House, one, they are sorted firmly, expeditiously, and they get justice most of the time. Mr. Speaker, this should serve us as an encouragement to members who sit in the various committees that handle different petitions. Petitions, Mr. Speaker, are an alternative form of dispute resolution that are firm in law, but also have got a greater force than even some of the long and winding judicial processes that exist in this country. Mr. Speaker, citizens know that if you present a petition before the Senate of the Republic of Kenya, chances are, before 60 days are over, you'll have received a response, and most of the time, if you're a citizen whose rights have been violated, you'll find that the findings of the committee will be in your favor, and they'll send good recommendations, either to the different government agencies that are able to resolve issues that will help citizens get justice from this House. Mr. Speaker, we should continue to look at petitions each and every time they are presented with this House in the manner that we have done. Mr. Speaker, the issue that is before the floor, presented by Senator Jones Maruma, is not a light issue. This is a very heavy issue among us, the people of a coast as a region.
land issues to them and how it has been handled by successive regimes is something that every time you interact with them, and we do this so often when we travel towards that region for our various committee issues, they keep on asking us, you as members of parliament, what are you doing about our issues? You know very well that one, we've been dispossessed of land, that every successive government has come in with a promise that finally they are going to sort the issues that bedevil land transactions at the coast, where most of the time they manipulate and take advantage of the not so well-educated citizens in that part of the country, yet nobody gives a firm resolution. I'd wish to challenge our colleagues who sit in the Land and Environment Committee, chaired by the very able Senator Mwangi Githiomi, to take time and canvass this issue with so much detail, because to the best of my knowledge, Mr. Speaker, this is not the first time that we are receiving a petition from the coastal region with regards to disenfranchisement on land rights and, you know, dispossession of property that belongs to them. I think there comes a time where, as a House, we must sort an issue with finality, such that this issue ceases being something that bothers the citizens. They are taxpayers. This House is run by contributions of taxes that come from the people of that region, and therefore they deserve to receive an equal share of the good work that this House continues to do, Mr. Speaker. NLC, which is a constitutionally mandated body to deal with many of these issues, gave a very vague ruling. I know this, Mr. Speaker, because the people that I represent in this House were also interested parties, having been dispossessed of land by the Queen's Rifles, land that up to date continues to be owned by multinationals whose home of operations are our former colonial masters, Mr. Speaker. Yet we have not been able to enforce that ruling because of the cavalier manner in which it was first of all issued, and the fact that NLC has not taken time to ensure that the various county governments have lived up to their expectations. There was even a recommendation that, first of all, for many of these multinationals and companies that do mining and explorations in the various parts of the country, they need to openly declare what size of land they control in the Republic. That once that declaration is made, then the second step that follows is establishing how they got that land in the first place. If they're dispossessed of people, they need to come out clear and say what are the repayment plans for the people and the inhabitants who are in that particular region. This hasn't been done, Mr. Speaker, and therefore I expect that when the Committee of Land is seized of this matter, once you give direction, that they will invite NLC, demand of them to give a status update of all the issues that have been presented before them in the last few months that have been in office. I'm aware that it's close to perhaps maybe 1 year before, after the new NLC team has been in office. And therefore, that will be a good time for them to present before this House, perhaps give even by way of a status report on what working framework they've set out this particular term, such that we don't end up with the kind of issues that we had during the term of the previous commission that served the first 6 years of under NLC. So, Mr. Speaker, there's a lot of work that is cut out for this committee. We'll be looking forward to read this report and the recommendations of the committee, and I hope that at the end of the day, the people of this particular region that have been mentioned in the petition will go home a happy lot and believe that indeed this Parliament of Kenya exists for the service of ordinary citizens of this republic like them. Thank you, Mr. Speaker.
Senator Omogeni.
Thank you, Mr. Speaker. I think, Mr. Speaker, Senator Mwaruma has raised a very important issue before the House. And, Mr. Speaker, if you follow the report on TGRC, there is no region which has been affected, especially by the poor inhabitants, like the coast region. Mr. Speaker, it's only in coast region that you find people we call absentee landlords. People who own big tracts of land that ordinarily should be owned by the local people. but who are nowhere, who are somewhere in the diaspora. And I'll invite my colleagues who are raising doubts on the misuse of the former presidents on allocations of land to take a keen interest and read the Truth Justice report. And then there was another report that was prepared in 2012 by a very reputable lawyer called Ndungu, referred to as the Ndungu report. Mr. Speaker, you'll find that these poor Kenyans were dispossessed of their land, and some of them are living at the mercy of very powerful people, very powerful individuals in this country. Every day they are reminded that they will be evicted. And I think as a house that represents the poor of the poorest, we should take a very keen interest when a petition like the one that has been presented before the House by Mwaruma is brought before us. So I hope that the committee that is going to look into this matter will dig deep into the recommendations that are in the Ndungu report and in the TJRC report and see how this injustice can be addressed. You know, Mr. Speaker, the recommendations in the TJRC have never been recommended because the National Assembly has never put in place the framework to ensure that reparations, the 10 billion shillings that was set aside for compensation, is utilized. So till and unless the National Assembly makes that fund functioning and actualized, Kenyans will continue to suffer. And I'm a bit disappointed that the county government of Taveta can just see people go to court, file cases, they get orders of eviction against the residents of Taveta without extending legal assistance to them. Because the case I've had being read by the senator, my good friend, Senator Mwaruma, was decided by the High Court. I mean, they still had another avenue of assisting these residents by filing an appeal to the Court of Appeal so that they set aside probably that order that was issued by the High Court. So I really hope that the governor for Taita Taveta, Governor Samboja, will also take a keen interest and extend some help to the people of Taveta so that the litigation that is taken to court by the people who own land can also be defended by the residents of those counties of Taita Taveta. Finally, Mr. Speaker, I also want to take this chance to update the House that on the issue of the advisory that was given by the Chief Justice, our advocates, Ahmed Nasir and company, have already moved to court. They filed the case yesterday, and as we speak, they are in court seeking for further directions on this matter. So I urge members to be patient. Ahmed Nasir is a senior advocate. He's actually one of our most respected senior counsels in this country. And
Let's consult in low tones.
And I'm sure, Mr. Speaker, that the interest...
Order, Senator. Senator Mugeni is communicating a very important message that affects all of us.
Yes.
So you better listen.
So, Mr. Speaker, I have a lot of faith and confidence. We, as the Committee of Justice, Legal Affairs and Human Rights, we had an opportunity to review the petition, the draft petition that was to be filed by Ahmed Nasir over the weekend. We gave our input, and I want to assure the House that he has raised serious constitutional issues that are worth being considered by the High Court, probably that may lead to reviewing that advisory that went to the President. I may not go into the details of the matter, but I want to assure the House that we are in safe hands, and we hope for the very best from our lawyer, Ahmed Nasir Abdullahi. Thank you, Mr. Speaker.
Okay, I see a lot of interest, but unfortunately, we have to go to statements. So, pardon. We are going to order, senators. Our time is up. Between our statement hour is between 3 and 4. We are already only 20 minutes to 4. So, order members, Pursuant to Standing Order number 2321, the petition is committed to the petitions are committed to the Senate Standing Committee on Lands, Environment and Natural Resources, which is the relevant standing committee for its consideration. In terms of Standing Order 232, the committee is required in not more than 60 calendar days from the time of reading the prayer to respond to the petitioner by way of a report addressed to the petitioner and laid on the table of the Senate. I thank you. Next order, we are going through the statements, and I want to rearrange so that we go to
Order number 5, papers. Order number 6, notices of motion. Order number 7, statements.
Okay, what's your point of order, Senator?
Bwana Spika, tuko na taratibu zetu za hapa bunge, lakini saa zile umesimama ndugu yangu Linturi, Senator Linturi, Senator shemegi yangu wa Meru, ameingia baada ya kubo, we bado huko unaongea na umesimama, akapita hivi na bado wewe unaongea, na akaenda mpaka pale akaketi. Lakini hata kama ni shemegi yangu, amevunja orodha ya hili bunge la Senate. Kwa hiyo Bwana Spika, ningeomba uchukue hatua mwafaka ya kumrekebisha huyu Senator Linturi, Senator wa Meru, ama aombe msamaha.
Senator Linturi, itabidi uombe msamaha ama ni ku
Bwana Spika, mimi ni mtiifu wa sheria, na nilipofika pale nilimbao, lakini ulikuwa umekaa chini. Singeweza kuingia kama ulikuwa umesimama, sababu nazifahamu sheria za bunge. Yaweza kuwa sababu sioni mbali, nimefika katikati ukasimama. Lakini Bwana Spika, kile ningeomba niweze kunipea nafasi nirudi pale nimbao na nitembee nikuja nikae, sababu mimi naheshimu bunge.
Hiyo ni sawa. Okay, statements, we want to rearrange so that we start with the Standing Orders 51(1)A. So the chairperson, Standing Committee on Health, to make a statement. Sought by Senator? Yeah. It was sought by Senator Beth Mugo.
Issuance of a statement by the chairperson, whom I am making on his behalf, Standing Committee on Health, regarding the consideration of a statement on the death of a patient at Mbisha Hospital due to alleged negligence. Mr. Speaker, sir, I rise pursuant to Standing Order number 51(1)A to issue a statement regarding the consideration of a statement. I rise pursuant to Standing Order number 51(1)A to issue a statement regarding the consideration of the Standing Committee on Health of a statement on the death of a patient at Mbisha Hospital due to alleged negligence. Mr. Speaker, at the sitting of the Senate held on Tuesday, 9th June 2020, Senator Beth Mugo MP requested a statement from the Senate Standing Committee on Health regarding the death of Ms. Virginia M. Asap, allegedly as a result of negligence occasioned by staff at the MP Shah Hospital on 26 May 2020. The statement sought to have the Standing Committee on Health investigate whether, contrary to Article 43(1)(a) of the Constitution and Section 7 of the Health Act, MP Shah Hospital caused the untimely death of the late Ms. Virginia Asap by putting commercial interests before her well-being. Mr. Speaker, in carrying out its investigation, the Committee on Health held meetings with members of the family of the deceased patient, the Ministry of Health, the Kenya Medical Practitioners and Dentists Council, KMPDC, the management of MP Shah Hospital, and the National Hospital Insurance Fund, NHIF. The meetings were aimed at clarifying the circumstances that led to the death of the patient, as well as understanding the broader legal, policy, regulatory, and structural factors that may have contributed to her unfortunate and untimely death. Mr. Speaker, the committee further resolved to refer the case to Kenya Medical Practitioners and Dentists Council on 17th June 2020 with a view towards establishing the following. A, the status of the rules and regulations pertaining to the provisions of emergency medical care in line with Section 112(1) of the Health Act 2017. The implications of MP Shah's treatment of the late Virginia M. Asap in relation to the current constitutional and legal provisions guiding the provisions of emergency care in Kenya, particularly Article 43(2) of the Constitution and Section 7, 12, 2B and 91(1)(b) of the Health Act 2017. C, relevant information on the gaps, issues, and challenges pertaining to the provision and regulations of emergency health care services. Mr. Speaker, Article 43(2) of the Constitution and Section 7(1) of the Health Act 2017 guarantees every person the right to emergency medical treatment. Section 91(b) of the Health Act further obligates all private institutions and private health workers to provide emergency services in the field of expertise as required or requested either by individuals, population groups, or institutions without regards to the prospects or otherwise of direct financial reimbursement. Mr. Speaker, sir, in the course of its investigation, the committee found that at the time of presenting at the hospital, the late Ms. Virginia Asap was conscious and stable as evidenced by the fact that she could communicate and that she made a payment of Kenyan shilling 9,000 for her treatment via M-Pesa at 4:51 a.m. Mr. Speaker, sir, the committee further found that the medical officer on duty who first attended to the patient correctly and promptly diagnosed the patient with acute ST, elevation myocardiac infarction, STEMI, MI with late presentation in consultation with the hospital cardiologist. Mr. Speaker, based on the patient's diagnosis, according to the established emergency medicine guideline and protocols, the appropriate deviance emergency treatment that the patient ought to have received was a percutaneous coronary intervention, PCI, coronary angiograph within 30 minutes of arrival at the hospital. However, in the case of the late Miss Virginia Asap, contrary to Article 43(2) of the Constitution and Section 7 of the Health Act, this emergency treatment, that is PCI, coronary angiograph, was delayed for an estimate 3 hours and 45 minutes due to financial motives. Mr. Speaker, sir, the committee also found that, according to submission by the family members of the late Miss Virginia, every medical intervention or treatment conducted on the patient by the hospital was only done upon confirmation of payment. For example, despite having presented to the hospital at 3:15 a.m. and a diagnosis of myocardial infarction being made at 3:30 a.m., the patient received the urgent medication she required after 4 a.m., and even then, only after family members had made a payment of 500,000 shillings. Sorry, 500,000 shillings. Mr. Speaker, sir, allow me to also note that the late Miss Virginia was a beneficiary of NHIF Super CAFA registration number 38